What you are witnessing right now is something the federal court system almost never sees. No cautions, no recess, no final warning. On direct instruction from Judge Marshals Caldwell, U.S. Marshals have stormed into the courtroom, confiscating materials, restricting movement, and effectively freezing one of the most explosive trials in recent history. The defense didn't simply make a mistake. They crossed a boundary so severe that the judge immediately shut everything down. After the shocking emergence of the so-called Witness 14 audio files, Judge Caldwell issued an emergency ruling that sent shockwaves through the legal community. Attorneys were ordered out, exits were secured, and armed marshals placed themselves between counsel and the courtroom doors. This wasn't a routine delay. It was a judicial emergency, a full-scale collapse of courtroom order. So, what caused such an extreme response? Less than an hour before marshals intervened, a devastating cache of recordings appeared online. These were audio files from confidential witness interviews, material protected under federal seal and never meant to be public. Even more alarming, the recordings allegedly reveal coordinated attempts to influence a protected witness by individuals tied to the defense. According to prosecutors, this is no procedural dispute. It is a direct attack on the foundation of the trial itself. And I now have the timeline, documents, transcripts, and visual evidence. I'm going to walk you through exactly what authorities say was uncovered. But first, understand who Judge Caldwell is. He has served on the federal bench for over 2 decades. He has overseen mafia prosecutions, terrorism cases, and massive RICO trials involving international criminal networks. He is known for being composed, restrained, and nearly impossible to rattle, until today. Multiple courtroom insiders say that when Judge Caldwell reviewed the contents of these recordings, his demeanor changed instantly. One court employee described him clenching his jaw and gripping the bench in silence. Then, he gave a single command: "Marshals, secure the courtroom immediately." So what was on those tapes? Witness 14, whose identity remains classified under federal protection, is a key insider expected to testify about large-scale financial misconduct tied to the defendant's organization. According to filings released amid the chaos, the witness possesses first-hand knowledge of forged records, concealed accounts, and coordinated efforts to obstruct federal investigators. The recordings reportedly capture 3 separate phone conversations between Witness 14 and people prosecutors say are connected to the defense team. In the first call, recorded 11 days before trial, a male voice tells the witness, "You don't need to remember everything. Being unsure works in everyone's favor." Legal experts say that statement alone raises red flags. But the second call is even more disturbing. 8 days later, the same voice allegedly warns, "If you bring up the March transfers, this becomes a much bigger issue for you and for your family." Have described this as classic witness intimidation, thinly veiled as advice. Then came the third recording. 72 hours before opening arguments, a different voice, this time female, delivers what prosecutors describe as devastating evidence. "Your testimony outline has already been prepared. Learn the summary. Stick to it exactly. If you go off script, your protection arrangement may not continue." In other words, prosecutors allege the defense attempted to script a federally protected witness's testimony and threaten their safety agreement. Sources inside the investigation say voice pattern analysis has linked these calls to phone numbers registered to 2 attorneys working under the lead defense counsel. One source told Reuters that when this information was presented to Judge Caldwell in an emergency meeting, he responded, "This court will not participate in the creation of false testimony." The recordings reportedly also include discussions about payments, future favors, and what happens to witnesses who refuse to cooperate. Former federal prosecutor Daniel Harrington, after reviewing portions of the transcripts, stated, "In more than 3 decades of federal prosecutions, I have never seen evidence this clear of defense-side witness tampering." Investigators say the evidence bundle includes 14 separate audio recordings totaling more than 6 hours, text message exchanges showing coordination, financial documents suggesting money was routed through a shell entity to relatives of witness 14, internal notes referencing testimony management. And here's the detail that stunned even veteran court watchers. Prosecutors did not leak these recordings. According to courthouse sources, the leak originated from someone inside the defense camp, a rupture from within. Someone on the defense side chose to torch the entire operation. Former Justice Department official Cassandra Webb told MSNBC that when a leak originates from inside a defense team, it almost never happens by accident. "That's not an error," Webb said. "That's someone deciding their career matters less than staying out of prison. It means the rot is deeper than anyone realized." In other words, this wasn't a paperwork issue. It wasn't crossed wires. Authorities say this was coordinated criminal behavior carried out by licensed attorneys. And now, it's preserved on audio. Make sure you're subscribed. This situation is unfolding in real time, and I'm posting updates the moment new developments surface. Turn on notifications so you don't miss what comes next. You've now seen the evidence. But to grasp how we reached this point, you need the backstory. This case, already labeled by legal analysts as the most significant white-collar prosecution of the decade, began 17 months ago with federal indictments against senior corporate executives accused of engineering a massive fraud operation. Prosecutors say billions were siphoned, pension funds were gutted, retirement accounts vanished, and bribes were allegedly paid to regulators to keep everything buried. From day one, the courtroom atmosphere was combustible. The defense, headed by veteran litigator Harrison Mercer, adopted an ultra-aggressive strategy. Every document was challenged. Every witness was attacked. Motions flooded the docket. Prosecutors were repeatedly accused of pursuing a politically motivated case. The government's team, led by Assistant U.S. Attorney Patricia Delgado, countered that the paper trail was overwhelming and the financial records spoke for themselves. 3 months into the trial, cracks started to appear. Judge Caldwell issued a rare formal warning after defense lawyers were observed speaking with a relative of a sequestered juror at a public restaurant. The defense dismissed it as coincidence. The judge did not. He called it dangerously close to obstruction. 6 weeks later, another red flag. A prosecution witness suddenly reversed key parts of their testimony during cross-examination, contradicting sworn deposition statements. Observers noted the witness appeared disoriented, hesitant, and oddly rehearsed, as if struggling to follow a memorized script. The prosecution requested a mistrial. Judge Caldwell denied the motion, but courtroom reporters say from that moment forward, his attention rarely left the defense table. Then came witness 14. This witness was expected to explain the core mechanics of the fraud scheme, how money moved, who authorized it, and how executives were tied to offshore accounts. One analyst called witness 14 the keystone holding the entire case together. The night before that testimony was scheduled, the audio files surfaced online. They appeared on an encrypted file-sharing platform. Within hours, they were circulating among investigative journalists. By 6 a.m., every major network had copies. By 8 a.m., prosecutors filed an emergency motion. By 9:15 a.m., Judge Caldwell called an unscheduled chambers conference. By 10:47 a.m., U.S. Marshals were deploying inside the courtroom. Reporters say when Judge Caldwell returned to the bench, His expression was rigid with contained anger. He did not sit. He remained standing, stared directly at the defense table, and said, "This court permits forceful advocacy. It does not permit criminal conduct." Then he issued the order that shut everything down. If this breakdown is making sense to you, hit like. It helps push this information to people who deserve to know what actually happened inside that courtroom, not the watered-down version. When the marshals moved, everything changed. Multiple witnesses say the entire sequence lasted under 90 seconds. It felt far longer. Judge Caldwell finished speaking. The defense team didn't move. Harrison Mercer started to rise from his chair, clearly preparing to object. Before he could speak, 4 marshals stationed around the courtroom stepped forward in unison. 2 approached the defense table. 1 blocked the main exit. 1 positioned himself next to the court reporter. Gasps filled the gallery. Several journalists later admitted they initially thought a violent threat had been detected. Mercer's face drained of color. Associate Counsel Catherine Vance stumbled backward, her chair scraping loudly against the floor. The lead marshal spoke clearly. "Counsel, remain seated. Do not approach the bench. Do not remove documents. Do not communicate with anyone outside this courtroom." A Washington Post reporter in attendance says Mercer finally managed to speak. "Your Honor, this is not..." Judge Caldwell cut him off. "I have the authority." 11 seconds of absolute silence followed.